Need so much space. Like the judge feels like.
Okay, Mr. Brinker, if you'd like to come forward, that's our first case of the day. People versus Robert Brinker, file number 255411.
Sierra Coke on behalf of the people.
Robert Brinker. Thank you, Jason Thompson, just stand by counsel, Mr. Brinker's representing himself.
Brinker's present here in the courtroom today for the record. And Mr. Brinker, is it your wish to continue representing yourself in this case?
Yes, sure. I mean, we got this far.
Well, I have to ask you every time by law. I'm required to confirm that before every hearing. Not because I'm expecting you to change your mind, but I have to make the record that you want to continue representing yourself. Of course, as you know, Mr. Thompson's here as standby. If at any time you want to stop the hearing and consult with him or ask him to be appointed as your counsel, I would grant you a break to do that and get a claim. Do you understand that?
Yes, sir.
Okay.
Yes, sir.
All right. With that in mind, Mr. Brinker, have you had an opportunity to review the pre-sentence report?
I just did, Your Honor.
Okay. Are there any corrections to the factual information in that report?
The fact, no, Your Honor, with regards to time served, I did end up doing 2 days on accident. They picked me up on a warrant that was lifted, and I was wondering if those 2 days credit could be put on there because it was just an invalid warrant. They came and picked me up, and then they released me the next day. They said, oops, because they rescinded the warrant, but I did do 2 days in jail for on this rescinded warrant. I was wondering if that could be credited, sir.
And that was the September 30th.
I believe so, sir.
Okay. Mr. McFelda, I know Mr. Haven's the one that did this report, but I mean, the report does reflect that he was arrested on that warrant and then released. Is there any reason why?
Judge, I mean, he was on parole when this happened, so I think that's gonna be.
Okay, that's true. So your parole status wouldn't allow you any jail credit for any time that you served?
Even if it wasn't a detainer or anything like that, Your Honor?
Yeah.
Okay,
By statute.
Okay.
If you're on parole, you're not entitled to any jail credit.
all right. I apologize then.
No, nothing to be
I
sorry.
was just asking.
Okay, any other factual information that's incorrect, names, dates? That kind
No,
of
sir, it all looks correct to me.
Okay. And again, I know you're representing yourself, but you do have the ability to challenge the scoring or any of the variables that result in the guidelines.
No, sir.
Is that something, because that's a highly legal type issue, is that something that you want a chance to consult with Mr. Thompson about? Scoring of the guidelines?
I mean, it all looks pretty correct to me, Your Honor. And I've known John for some time. He wouldn't. Okay, so,
That's fine. I just want to give you that opportunity.
yes, sir.
Okay. All right, Ms. Pope, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this morning?
No, Your Honor. It's scored properly.
Okay. Is there anything that you have on behalf of the people?
This case is really hard. This court's very familiar with Mr. Brinker. I've been dealing with Mr. Brinker in a professional capacity for well over a decade at this point. I think he's been continuously on parole the entire time. He is doing well. This is sort of a double-edged sword because he's doing really well because he's adjourned this case way out. We're 2 years past the time of the conviction. And in a lot of ways, I don't want to say, hey, we should give him credit for all these things he's done for 2 years while he effectively did every possible trick in the book to delay this case. Because I don't want it to become an idea that you think that if you adjourn things out and you're doing well, that works in your benefit because you've done all kinds of crazy things to make this case take forever. I can't think of another case we have on our docket that's this old, and it's because of all the different things that Mr. Brinker did. He is doing well. Probably for the first time in a really long time. He has 16 felonies and 15 misdemeanors, and he's 44 years old. I talked to Bobby more than any other defendant. He sends me lots of emails with updates about his life. He really could have done something way different with his life if he had made better choices. He was very intoxicated at the time of this offense while he was driving. He'll tell you why, I'm sure, and we'll hear about it. I did give him a plea offer without the habituals, and he'd be looking at significantly more time had I not. So I try to take into consideration all the things that were going. He does have the support of his mother, who always shows up for him, and he breaks her heart pretty regularly. So I'm hoping that maybe just for once, he could do something right and get his life on track. However, the court fashions that sentence, the prosecution would be fine with. Thank you.
All right, thank you, Mr. Brinker.
Yes, thank you for allowing me to speak. First, I want to say I understand the seriousness of this offense, regardless of the circumstances. I was a person behind the wheel, and I accept responsibility for that. At the time of this incident, it was September 2024. I became extremely ill and was later hospitalized for 50 days with sepsis and multiple bacterial infections, the temperature 103. While I cannot fully explain what happened leading to that day, I understand that my actions resulted in this case before the court today. The positive changes in my life did not begin after this incident. Before this happened, I had already enrolled in college and I had begun participating in outpatient treatment. I wanted to improve my life and make better decisions. Those efforts were not court ordered and were not started because of this case. I have remained drug-free since July 14, 2021. And I have worked hard every day to maintain recovery and continue moving forward in a positive direction. Since this incident, I have continued on the same path. I've remained involved in counseling and treatment. I've continued my education and stayed focused on building a better future. My treatment providers have given me positive feedback regarding participation, accountability, consistency, and the commitment to recovery. And I have documentation supporting that progress and continued involvement in treatment. During this time, I completed my associate's in applied science. I graduated in May with a summa cum laude honors, finished at top of my class. I'm proud of that accomplishment because it reflects the hard work, dedication, and commitment I have put into changing my life. I hope continued education, additional HVAC coursework, depending on the sentence imposed by the court. I have also received employment opportunities and academic performance recommendations by instructors. This case has had a major impact on my life. I had remained law-abiding and focused on my education and commitment to treatment and determined to build a better future. I have invested a significant time, effort, and resources in improving myself in this case pending. I'm not asking this court to excuse my conduct. I am understanding accountability is necessary, and I am prepared to accept whatever sentence this court believes appropriate. I respectfully ask this court to consider the progress I have made both before and after this incident. The court believes it is appropriate. I would ask for consideration. Any sentence options would allow me to continue to maintain my education and continue treatment, address my ongoing needs with care for my family, and keep moving forward while I still being held accountable for my actions. I can only promise this court that I will continue doing things that have helped me change my life and work every day to justify the opportunity the court gives. Thank you for your consideration. I just graduated in May, summa cum laude, top of my class. I walked the aisle and stuff. It was like one of the proudest moments of my life. And I just worked really, really hard I've been in treatment since 2024, 8 months before this case even happened. And I've been going there every month, nonstop for the last 3 years. And they give me nothing but good reports. I enrolled myself in that, and I enrolled myself in the college as well, and did excellent. And I did have this mistake happen. I'm not proud of it because I've just been working so hard to be a good man. Really hard.
So Mr. Brinker, obviously I'm well familiar with you. You've been in my courtroom many times since I took bench 13 years ago. And so I really don't think any of us need to say anything about your record. We all know what it is.
Yes,
all
sir.
of us in this courtroom are familiar with you. And not just your record, but your past behavior and some of the things you've done. I think I can speak for all of us hard to understand. And I'm sure a lot of it is driven by the substance use.
Addiction.
Because I don't think a rational person would do a lot of things.
No, sir.
Done. So, you know, that's hard to get past. And I think Ms. Coke probably, I've spent a lot of time with your case over the past couple of weeks since I got PSI. Going back and forth, honestly, about what is the right way to go forward here. Because based on your record, a prison sentence is absolutely warranted given what happened in this case. And it's within the guidelines, and it's something that I think is perfectly reasonable to propose, given all the circumstances. No matter what you've done in the interval. The flip side of that coin is, you know, I was surprised and fairly impressed by what you've done since this charge, since you were arrested on this charge. And I tend to agree with Ms. Koch, certainly that delaying a case to try and do good things in order to get a lighter sentence is not something that we would encourage. And we do see that from time to time. We're just flat out delaying a case for as long as possible. But I think what you've done in terms of your education and treatment in that interval is more than I think what I would expect somebody who's just trying to delay would have done. I mean, it just appears to me, I don't think you could have accomplished without making some honest effort towards doing that. And so that's the flip side. And you know, just
Worked hard.
it's hard to you know, even in light of that, it's hard to give you another opportunity given everything that's happened. And I have concerns for safety of the community and so forth, because if I do give you another chance and mess up, I don't want to be putting other people at risk. And then later it's like, why in the world would you give this person another chance with this kind of record? So I'm just saying this because these are the kind of things that I'm thinking about as I'm trying to think of the best way to go forward here when but I think ultimately where I come out with it is to give you another opportunity because of what you've done over the past year and a half. And it put you on probation for a lengthy period of time. I'm going to impose the jail time, but I'm going to hold that in abeyance. And I think, I don't even think I need to say this, I'm sure you understand it, but if there are any probation violations, that's it.
I understand that, Your Honor. I appreciate that.
I just think that, you know, what you've done in terms of your education, trying to move forward, I think a lot of times, both the prosecutor and court, and even sometimes the defense attorneys are just, they don't care about the people that come before them. But I think what all of us want is for people like you who have extensive records that have messed up, is to finally make some kind of change in their life, do something different. I think we all want that. And I think people in general want to see other people do well and do better. And you know, you've made some significant indications that you're on that road. So I'm gonna give you another chance.
Thank you so much.
If you understand that, again, if there's any problems, then that would be none of that. So the court is going to sentence you to probation for a period of 36 months. It's longer than the term recommended here.
Okay.
But I think the longer you're under supervision, the better off we all are, including yourself. The court is going to impose all the terms and conditions listed in the report. The court is going to impose 12 months in the Crawford County Jail. You do have credit for 0 days served. That time to be held in advance and be served at the discretion of the court.
Your Honor, I do, just for the record, I do believe he has to get 30 days statutorily because it's an OWI third. And he didn't do a sobriety court. So I think by law, we have to do the 30 days. I defer to the court, but I think that's the rule for OWI thirds.
You're right on that. So first 30 days to be served, the remaining time to be held in abeyance. To be served at the discretion of the court. Restitution in the amount of $150. Payable to the Crawford County Clerk to be dispersed in the prosecutor's office, crime victims assessment of $130. Court cost $325, $68 state cost, $500. OUIL reimbursement of $107, $50 supervision fee while you're on probation. You have the ability to seek an appeal of this sentence, Mr. Thompson. I just like to review helping Mr.
I was, Your Honor. He accidentally signed on the request and I had him cross that out. He's now initialed it. So he's not requesting attorney at this time. He understands he has a right to. He's just indicated no proceed on a copy I handed to the clerk.
Ms. Koch, is there anything else we need to address on this file today?
No, thank you.
Okay, so Mr. Brinker, you're going to be taken into custody today to serve this required 30 days.
Yes, sir.
And Mr. McFeather, are you going to be the supervising?
I will, Judge. I'll meet with him at the jail.
All right, and I guess I'm just I want to say this for the record. I'm sure you already know it's based on my comments, but Mr. Brinker, I'm holding that time in advance. That means
I
that,
messed up. Now getting hammered.
well, what it means is I don't even have to go through a probation violation hearing and all of that. So I can just put him in jail for a year.
Yes.
Then we'll have the probation violation. And if you're found guilty of that, well, you're likely to go to prison.
I understand that.
And Mr. McFalda knows that I'm gonna want him to be following your case very carefully, and there's gonna be zero room.
I go back to school in the fall for HVAC to learn to get my certification from there as well. I got a job waiting in Roku.
That's all great. I just want to make sure that you're clear that there isn't gonna be any wiggle room here for you at all.
I know.
Bobby, she's gonna grab it. You just stay right there. Okay. It's a bag with meds.
Meds in my legs charger and stuff. I got.
Keep it around to the jail too.
You can, honest, everything's in there. I mean, just get the bag, just bring the bag.
Bobby, calm down.
I apologize, that's my jail bag.
It's all his legs now.
Yeah. Sorry, Garner.
Okay.
All his legs.
All right, do we have Mr. Jackson present?
I will check the lobby, Your Honor. I was in contact with him yesterday. This is
No, because I'll kill him first.
I don't see him, Your Honor. Are we on the record?
Yes.
Your Honor, Jason Thompson, on behalf of Defendant Christopher Jackson. He's been in good email contact with me. He's been consistently, saying that he has great difficulty trying to find a ride. I encourage him to come here today. I even obtained a gas card for him, to try to help him make it back. So I don't know why he's late. That's all I can say, Your Honor.
All right, we'll pass that for now and we'll come back to that one. Is Mr. present? Yeah. Hold on one second. I want to make sure your attorney's available first. Yes, okay. All right, Mr. Love, if you come up to the podium, please. We'll go on the record in People versus Scott Love. This is file number 265536. The record should reflect that Mr. Love is present here in the courtroom today. Mr. Trush, are you able to hear us all right?
Yes, Your Honor. Thank you. Richard Trush appearing on behalf of Mr. Love.
Okay. Mr. Trush, can you tell me the status of this file?
Yes, Your Honor. We are in receipt of an offer from the prosecutor's office that if there was an admission to count one, that's assault with intent to do great bodily harm, The remainder of the complaint would be dismissed. I'm not sure at the bind over. I don't think count 2 was bound over, but there is a habitual offender that would be dismissed.
All right, I didn't hear the first part of what you said. Is this a guilty plea to count 1 or a no contest?
A guilty plea, Your Honor.
Okay, so guilty plea to count 1, no enhancements, no additional charges.
Correct.
All right, Ms. Polk, is that your understanding?
It is.
Okay, Mr. Love, is that the plea agreement that you've discussed with your attorney?
Yeah, that is my plea agreement that I have discussed with my attorney.
Did you want to go forward with that today?
I did want to go forward with that today.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Love, are you currently on any kind of probation or parole?
I am not.
And you understand the maximum possible penalty that you could face for this charge would be up to 10 years and or a $5,000 fine?
That is correct.
With that in mind, what is your plea to that charge?
Guilty.
Right now, you have certain rights. I'm gonna go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
I do. Thank you for reading them slow.
And do you understand that you're going to be giving up all of those rights by pleading guilty?
I do today, and I'm kind of uncomfortable with it, but it's all right.
Okay. Also, if you wanted to appeal the plea that you're making here today, you don't have an automatic right to do that. You'd have to ask for the Court of Appeals to hear that case. If they said no, then that would be the end of that appeal. You understand that?
Understood.
1 second. Sir or ma'am, I'm going to ask that you have your child go out of the courtroom. We, number one, I don't think it's an appropriate place for a small child to be. We're going to be talking about a lot of adult things in here, and I don't think it's appropriate for young children to hear. So, okay, Mr. Love, has anybody threatened you with anything to get your plea guilty?
Nobody's threatened me with nothing, sir.
Has anybody promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
The information I have indicates this happened on November 25th of 2025. Is that the correct date?
I'm not sure on the exact date. It's kind of gone out of my brain. So I do know the incident occurred. I just don't know the exact date.
Do you have any reason to doubt that kind of late November of 2025 time?
No, I don't have no reason to doubt that. I was thinking early October, but I knew it was somewhere right around there.
Okay. And this was an assault that involved an individual with the last name of Severance, is that correct?
Dan Severance,
And what was the address that this occurred at?
6441 Center Street,
Here in Grayling?
here in Frederick.
Oh, Frederick.
Yes,
Okay. And that was a part of Frederick that's in Crawford County.
yes.
And
Your Honor, would the court like me to assist with the factual basis?
yeah, the information doesn't really provide much detail.
So, Mr. Love, on that date in Frederick, did you have a physical altercation with Mr. Severance?
I did.
And during that physical altercation, did you punch him?
Yes, I did.
Did you punch him once or more than once?
More than once.
And as a result of those punches, did he suffer a broken nose?
Correct.
Your Honor, I think that would provide a factual basis for the court.
I would agree.
Okay. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Trush, are you?
No, Your Honor.
Ms. Koch, are you satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Trush, are you?
Yes, Your Honor.
Mr. Love, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney, Mr. Trush, between now and then.
Okay,
And before you leave today, you're going to touch base with Mr. McDowell from the probation department. He's going to set up a time for a pre-sentence.
thank you.
Thank you. That's all.
Yeah, Your Honor, just briefly, Mr. Love was requesting 60 days before the sentencing. He has some arrangements to make in terms of his living situation. Additionally, we're working with CMH to get some information to the court. So I'd ask for just a little longer time period for that sentencing.
Do you have any objection to that?
No, I just had three things that I need to do, a bank account, a
That's
truck.
okay. I don't need to know the details. Ms. Coe.
Your Honor, frankly, this is a pretty severe assault. The victim was pretty injured in this case. We've adjourned it out numerous times. I mean, if we have to set out 30 or 45 days, I think you can make those arrangements. I don't know why we've already adjourned it numerous times at defense request.
All right, without a stipulation, Mr. Trush, the court is going to set it for sentencing at the normal interval. So, Mr. Love, you're going to have about 30 days to take care of it. Okay.
Thank you.
Thank you. That's all.
All right.
All right, is Mr. Bunker present? Yes, sir. Mr. Bunker, if you can come up to the podium, please. We'll go on the record in People versus Levi Bunker, file number 265553. The record should reflect Mr. Bunker's present here in the courtroom. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Bunker.
Mr. Trush, can you tell me the status of this file today?
Yes, Your Honor, we do have an agreement for the court that we would intend to accept today. The agreement contemplates that there would be a plea to an added count 5. That would be larceny, more than 200 but less than 1,000. And we would seek that being the 1-year misdemeanor, we would seek to take advantage of that.
That's a correct statement of the plea offer. It includes truthful testimony against his co-defendants. We were going to ask some additional questions on that, specifically to Andrew Barshaw.
Okay. All right, Mr. Bunker, is that the plea agreement that you've discussed with your attorney?
Yes, Your Honor.
Is that how you want to proceed today?
Yes, Your Honor.
You raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Bunker, are you currently on any probation or parole?
Probation,
Where's that from?
right here in Crawford County.
What's
With
that?
my age.
Felony probation?
Yes.
Okay.
Well, 74
Okay.
Your Honor, just so the record's clear, I think these offenses predate his probation, so he wasn't on probation at the time this occurred.
Okay, thank you. And you understand that the maximum possible penalty that you can face for this added count 5 of larceny of over $200 is up to 1 year in jail.
Yes, Your Honor.
And of course, any restitution, fines and costs. I understand that.
Yes, Your Honor.
With all of that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial to yourself if you want it. You understand all of those rights.
Yes, Your Honor.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here on the record?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of this charge?
Yes, Your Honor.
All right, I guess, Mr. Trush, As with the previous case, are you prepared to take proofs from your client?
Yes, Your Honor, I think I could ask him some questions to establish a factual basis.
Okay, thank you.
So on or about March 6th of 2024, were you here in Crawford County?
Yes, Your Honor. Yes.
And on or about that time, did you have some contact with Andrew Barshaw?
Yes.
And did that contact involve him bringing to you a trailer with some snowmobiles?
No, it was a camper.
Okay, so he brought a camper to you?
Yes.
Okay, and when he brought that camper to you, what did you do with the camper?
He was living out of it. It was just on where I was renting, it was on the property.
Okay, did there come a point in time when Andrew brought a trailer with some snowmobiles to you?
Yes, Your Honor. I mean, yes.
Okay. And did there come a point when you came to recognize that those snowmobiles were not Andrew Barshaw's?
Yes.
Okay. And was he storing those things on your property?
Yes.
Okay. And you would agree that that assisted him in concealing that stolen property?
Yes.
Okay. And what happened to those snowmobiles that he had brought to you?
I honestly can't tell you. They were there one day and gone the next.
And you agree that you had no lawful authority to possess those snowmobiles. Those weren't yours.
Yes.
Your Honor, I think that that would establish a factual basis for aiding and abetting the theft of those snowmobiles.
Ms. Coe, do you have questions?
I do. Mr. Bunker, did you do an interview with the police about the items that were stolen, that were on your property and otherwise?
Yes.
Was everything you said to the officers factual in that interview?
Yes.
Okay, there was a Chevy Avalanche. Do you know anything about the Chevy Avalanche?
Yes.
Where was that stolen from?
From right here in Grayland.
Okay, and where were you with Mr. Barshaw when it was stolen?
No,
Okay, and how do you know that it was stolen?
because I didn't know where it came from.
And have you ever been to the property where it came from?
Yes.
Okay, when you went to that property, who were you with?
Andrew Barshaw.
And what did you do on that property?
I dropped him off there.
Okay, and when he left with that vehicle,
Yes.
and that was not Mr. Barshaw's property,
No.
and you saw him driving that Avalanche?
Yep.
Okay, no further questions.
Ms. Coe, do you agree that there's a factual basis for the edit count 5?
Yes.
Mr. Truce, do you?
Yes, Your Honor.
Ms. Coe, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Truce, are you?
I'm aware of none, Your Honor.
And Ms. Coe, are the people satisfied that the court has complied with statute and court will take taking of its plea?
Yes, Your Honor.
Mr. Truce?
Yes, Your Honor.
Thank you. Mr. Bunker, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Truce between now and then. So you're going to meet with Mr. McFelda before you leave today for misdemeanor pre-sentence report interview. Mr. Truce, anything further today?
Not in regards to this file, thank you.
So,
No, Your Honor.
okay, thank you. That's all for today, Mr. Bunker.
Thank you, Your Honor.
Okay, Mr. Iverson, if you can come up to the podium, please. The Go on the record, Go versus Iverson, file number 265555. The record should reflect Mr. Iverson's present here in the courtroom today. If I could have counsel to your.
Here, Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant Zachary Iverson.
Mr. Thompson, can you tell me the status of this case today?
Yes, Your Honor. I am going to be requesting some more time. I've retained an expert. Courts, I believe, received a stipulated order regarding that expert's ability to access the materials and also accessing Mr. Iverson's juvenile file. I believe I should have a report within 45 or 60 days.
What I'm thinking, I mean, just given the nature of the charges here, I mean, have there been any plea negotiations? Is that something you think is?
Yeah, that's definitely possible, Your Honor. I'm not asking the court to set this for trial.
I understand they have to do the expert. We've been working with Mr. Thompson to get him the documents that are required that the expert is allowed to have access to, because we can't just give them to him. I would not object to the adjournment for that purpose, but I would ask that the next date in 60 days out is the plea cutoff, so that we either get a plea or move towards trial, given the age of the victims in this case.
Do you think you can have enough information within that 60 days for your client to make a decision?
Yeah, I will do my best, Your Honor. And if situation changes, I'll address that with the court.
So we'll set this for a plea hearing status conference in 60 days. Mr. Iverson, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
All right. Anything further on this file today, Mr. Thompson?
Today, Your Honor.
Thank you, Ms. Cope.
No, Your Honor.
Thank you, Mr. Iverson. That's all for today.
Thank you. Just back. This is just your notice. Yeah. Yes. Okay. See if I can remove the price.
Okay, the court calls People versus Mallmeister, file number 265556.
Here, Coke on behalf of the people.
Mr. Mallmeister, can you come right up there? Am I saying your name correctly?
Yes, you are. All right. Thank you, Your Honor. Jason Thompson, the defendant, Tate Mallmeister.
Mr. Thompson, can you tell me the status of this case?
Your Honor, I did receive a plea offer in this matter. I believe there's some additional things Mr. Mallmeister wants me to look into. So I'm asking you to days on this. Let's go.
No objection. The plea offer was made 2 months ago. We would ask that the next date be the plea cutoff.
Mr. Thompson, is there any reason why wouldn't have enough information to advise your client about a plea between now and that next hearing?
No, I think that'd be fine.
Okay, so Mr. Mallmeister, we're going to have another hearing in about 30 days. Between now and then, it's important that you talk to Mr. Thompson about any plea offers that are out there. If you want to enter into a plea offer, then we'll take your plea at that next hearing. If you don't, then the court will set it for trial, and we won't accept any pleas to any lesser charges after that date. So I'm going to need you to come to that next hearing prepared to make a final decision about any plea offers. Okay?
Yes, Your Honor.
Do you have any questions about that?
No, I don't.
Okay. All right, so we'll set that for a plea cutoff in 30 days. Mr. Thompson, anything else that we need to address?
Not for today's record, Your Honor.
Ms. Coe.
No, Your Honor. Thank you.
So again, Mr. Mallmeister, make sure that you stay in touch with Mr. Thompson so you're ready with the decision on that day. Thank you.
Thank you, Your Honor.
This is Ashley Wall, file number 265559. Record should reflect Ms. Wall present here in the courtroom today.
Yes, sir.
I could have counsel put your appearances on in this case.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Ashley Wall. Your Honor, we do have a plea offer in this matter. It does include 74. No, so it's added count 2, possession of less than 25 grams. It's MCL 33374032855. So that's the 4-year maximum, and prosecution would have no objection to 7411.
Okay, Ms. Coe.
That is a correct statement. The offer 7411 is not part of the plea, but we are not objecting if she's eligible. Based on her criminal history that I can see, she does appear eligible.
And it's my understanding she's eligible, Your Honor.
Okay, thank you. Ms. Wall, is this the plea agreement that you've discussed with your attorney?
Yes, Your Honor.
Is that how you want to go forward today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Lower your hand. Ms. Wall, are you currently on any kind of probation or parole?
No, Your Honor.
And you understand that the maximum possible penalty that you could face for this charge of possession would be up to 4 years and or $25,000?
Yes, Your Honor.
With that in mind, what is your plea today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're in trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial, to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. And that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty?
Yes, Your Honor.
This occurred back on March 9th of 2026. Is that the correct date?
Correct. Yes, Your Honor.
On that date, were you present here in Crawford County?
Yes, Your Honor.
While you were here in Crawford County, did you have possession of some methamphetamine?
Yes, Your Honor.
Did you know that that's what that was?
Yes, Your Honor.
Did you have any legal right to have any amount of it at that time?
No, Your Honor.
Ms. Polk, are you satisfied with the factual basis?
Yes.
Mr. Thompson?
I am.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute, the court rule in the taking of this plea?
Yes, Your Honor.
Yes.
Ms. Wall, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important between now and then that you stay in touch with Mr. Thompson so that you're ready to go forward on that date. Also, before you leave today, you're going to meet with Mr. McFalda for probation to set up a pre-sentence report. Do you have any questions?
No, Your Honor.
Mr. Thompson, any further on this case?
I just wanted to confirm with the clerk, some of the documents have a typo on her address. Her address should be 919 Kosciuszko Street in Manistee.
That's what I have.
All right, thank you.
Ms. Polk, anything further on this file?
No, Your Honor.
Thank you, Ms. Waller.
Thank you, Your Honor.
Talk to her now.
Mr. Johnson? Yes. Come forward, please. We'll go on the record in People versus Andrew Johnson. This is file number 265558. The record should reflect Mr. Johnson's present here in the courtroom. This is the date and time set for sentencing. If I could have counsel for your appearances.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Andrew Johnson.
This is, again, the time set for sentencing. Mr. Johnson, have you had a chance to go through this pre-sentence report? Talk to Mr. Thompson about that?
Yes, Your Honor.
And Mr. Thompson, my first question, I guess, is jail credit. Because
Yes, I wanted to, so my update for the court is on Tuesday, 2 days ago. Sorry, so that'd be the second. Mr. Johnson was incarcerated. The district court sentenced him on the contempt in this file to 30 days. So he's got 3 days credit so far. He does have a 30-day sentence from Judge Burmeister for non-appearance in this file.
So we've got 8 days of credit total.
Correct.
All right. Are there any other corrections to the report?
No, Your Honor.
Are there any challenges to this warrant?
No.
Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Challenges to this warrant?
No.
Anything on behalf of the people for allocation?
So this, yes, this case came to us in a really strange fashion. So Mr. Andrew Johnson was arrested for drunk driving, and he went to the jail and pretended to be his brother. So his brother came to the arraignment and said, I don't know what's going on. I was never arrested. This ensued. I couldn't even tell you the number of hours that my staff and the sheriff's office put into correcting the problems that came as a result of this, which included trying to contact Secretary of State, because then the wrong brother's insurance went up and it went on his driving record, and all of these things that happened that really had a negative effect on his brother. His brother and his brother's wife called our office well over a dozen times, calling us about the things that had happened as a result of this. It showed up on his criminal history, something about a job, and they saw it on there because the arrest was on there. It was the nightmare for us. And then they started calling saying that Andrew was ducking because this went on forever. He ducked the subpoena for almost 2 years. He absconded. And they were saying that the sheriff's office over in Mayo knew where he was and they weren't being involved, and on and on and on and on. So I don't think that Mr. Andrew Johnson understood the negative effects that this would have by lying to the police officers. I think that the idea that he would get no jail at all for this is preposterous, that he should focus on rehabilitation. His brother indicated this is a long history of him doing this. This isn't a new situation. But this had a very negative effect on lots of things. Like, you're talking about somebody's criminal history, you're talking about their driving record, you're talking about their life. And to just say he needs to focus on rehabilitation is incorrect. He was drunk driving, which, we're here for, which is one problem. But then to lie to the police and go to the jail and continue to lie about your identity all the way through the entire process, and then get out and let somebody else be on the hook for it is something that deserves jail. I defer to the court on how much jail, but he got 30 days just on the contempt for not showing up in the 2 years he absconded on his warrants. He clearly knew he was arrested. He clearly knew this process had happened. And he was just going to let his brother take responsibility for his drunk driving. I think he should get at least 30 to 60 days on the underlying charge. Thank you.
All right, so just so that I'm clear, because it wasn't clear to me when I read the report, his brother wasn't involved in this. So I didn't know if these guys were running some kind of game, both
No.
playing, the ends against the middle. But
No.
his brother was not involved.
No, his brother was not involved at all and didn't know anything about it. Although once he had to come to court, he knew, of course, what happened.
Right.
But no, he wasn't involved, and they were very upset. We spent hours trying to work with Secretary of State, trying to get his driving record fixed and then his insurance record fixed to get it, because he's got this drunk driving, and it was bad. It was a bad situation that Andrew just didn't care about. Had he just, owned up to who he was, we would not be in this situation. We wouldn't be looking at a felony. His brother wouldn't have had any of the consequences. They're not here today, but like I said, our office talked to them well over a dozen times as a result of this behavior. So that's all. Thank you.
Thank you, Your Honor. I mean, I would disagree with the premise of the prosecutor's argument that, the recommendation should be thrown out because he should do some jail time. He's going to do jail time. He's got 30 days of jail time from Judge Burmeister. And respectfully, Your Honor, I think that strikes a balance between the recommendation, the prosecutor's objection, and the condition of the defendant, which is he's in a lot better place in his life now. He still has to pay for what he did 2 years ago. He drove drunk. It was his second drunk driving. He's going to lose his license. He's going to get a very significant sanction from the Secretary of State. He gave his brother's name. That was disingenuous. He shouldn't have done that. And he's now got a felony on his record, Your Honor, and the court knows how significant that is. He missed court then when he was charged, and he's doing 30 days in jail. So I disagree with the premise that he's not facing punishments. Obviously, it's within the court's discretion to impose additional jail time. And I understand the court may be considering that. Mr. Johnson has really straightened his life out. He was drinking entirely too much back then, was entirely too irresponsible. He was irresponsible with this whole court process. It did lead the prosecutor to have to do hours of work. I don't doubt that. But he has since gotten himself back on track. He's done it, you know, what I think is usually the best way to do it. He's really focused on work. He's become a supervisor at his work. He's a person who's counted on and respected, and is learning and has learned and showed how to be dependable, how to be reliable. Obviously, this thing he did 2 years ago, he deserves to face a consequence. He's standing before you in orange because he's paying a consequence. When he shouldn't have done that, he has made his amends with his brother. You know, he gave his brother's name and birth date. When a person doesn't have an ID on them, that, you know, can lead the system to processing that. He shouldn't have done that. He's essentially getting sanctioned, I think, very heavily for that. That could have been a misdemeanor. Prosecutor insists on a felony here. He's got a felony conviction, Your Honor. So we're asking the court to follow the original recommendation of probation here, bearing in mind that he's doing the 30 days right now. Thank you.
Thank you, Mr. Johnson. Anything you wanted to say?
Yes, Your Honor, I would first like to apologize for the courts and Ms. Cope for everything that happened and putting that stress on them. Me and my brother actually just had a barbecue a few days ago. We, you know, made amends, and he understands that I messed up and wasn't in my right mind. Now I'm working for one of the biggest Misaki oil and gas companies in Michigan. I just bought a house, so I'm paying a mortgage. I have full custody of my daughter now. And they're holding my job for 30 days, but anything after that, they can't help me with. And I really don't want to lose this job because I'm also concurrent on all my child support. So I don't owe anything. And that was a big thing to come over. That was $40,000 I had to pay. And I am really sorry to the court, and I would just wish no more jail time, because I don't think that would help me in the end, because I would lose my job, I would lose my house, I'm paying mortgage on it right now, I have a car payment, and then right now my dad's taking care of my daughter for me. I need to be there for her, and I'm just really sorry to the court. That's not who I am. I hope nobody sees me like that at this point.
All right, I did read through the report, so I'm familiar with what happened, the circumstances that bring you before the court here today. Of course, I've heard a lot more detail about it from both sides. And so I take all of that into consideration, along with what you've had to say and what the information in the background or of your background into the court. And, you know, my first kind of impression of this, like I said, I didn't know if your brother was involved in it and they got charges identity theft, or whether, you know, you really were doing something that he had no idea about. And it seems to be flattered, you know,
I did call him afterwards when it happened and called up to the courts, and that's when things started to get fixed. So,
but I can also imagine the amount of red tape and how difficult it is to unwind something like that once it's been wound up, just because of all the different agencies involved. And I certainly think there's potential even in the future, when even after you think everything is taken care of, for there to be negative consequences to your brother based on this. And so I think there's a price to be paid for all that time and effort that's gone into correcting something that, like Mr. Thompson said, would have been a misdemeanor for you. Drunk driving, that is made so much worse by this, and required a lot of time, effort, and resources by a lot of people. And so I absolutely think there's a price that needs to be paid for that. I think probation is appropriate. The court is going to follow the recommendation for probation for a period of 1 year. The board is going to adopt as the terms and conditions of that probation all the terms and conditions listed in the report. court is going to require that you serve jail time of 90 days in the Crawford County Jail. You do have credit for 8 days served. That time to be served concurrent with your sentence for contempt. The court is going to order a private assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, $68 state cost, and a $30 per month supervision fee while you're on probation. All of that applies to the identity theft charge. That's the operating while intoxicated charge. 90 days in the Crawford County Jail with credit for 8 days served, that to be served concurrent with counts 1 and the sentence, a fine of $200 and the state cost of $50. You have the ability to seek an appeal of this sentence, and Mr. Thompson, if you can provide Mr. Johnson with receipt of this.
You're gonna initial there, so that indicates you've received it. If you wish to pursue an appeal, you're gonna move to pursue copies. You would fill this out. You can cut it out of the jail.
So I have to do 90 days as of now.
Correct.
Yes, that's the court census.
Okay.
Take those with you, use those.
Or again, it has to be a common consent.
Check the lobby again for Mr. Jackson.
And you're out there, you can see if there's a, oh, are you Miss Owens? No. Is that a EV ring?
It is. I would not expect her, just based on some of the case notes I've been reading, so.
I'll give it a little more time.
Okay.
All right, we have Ms. Caswell present. On the record of People versus Caswell. Is file, this is file number 265533. The record should reflect Ms. Caswell's present here in the courtroom.
Sierra Coke on behalf of the people.
Good morning, Your Honor. Ryan Slepp appearing on behalf of Ms. Caswell, who's present and standing to my left.
Your Honor, in this case, we do have a plea agreement. It's kind of complicated. And it's a little different than what we normally do. So hopefully the court will let us do it. But this is what our anticipation is, that she'll enter a plea to an added count 4, which is a felony, larceny over 1,000, but less than 20,000. That PAT code is 750.3563A. And that's a low severity felony. But if she is successful on probation and she pays the full amount of restitution owed, which is $25,633, at the end of her probation and after the restitution is paid off, she'll be allowed to withdraw her plea and enter a plea to a misdemeanor, which is one step below, which is the larceny 200 to 1,000. This is going to effectuate the holding the hammer over her head with the felony if she doesn't pay the restitution. And the primary goal in this case is to get the restitution paid and get the victims made whole again from this larceny.
What's the maximum possible penalty for this larceny?
I apologize. I think it's a 5-year, but let me just, it's a 5-year and then it's the treble damages.
Is there any agreement on potential jail time?
There isn't, but I did speak to, it's 5-year and or $10,000 or 3 times the value of the property stolen. That's the maximum. But I did indicate to defense counsel that given she has absolutely no criminal history and the goal is restitution, it is unlikely that jail would be recommended up front. If she had a payment plan set up and she had taken some type of economic crime class, and she had a plan on how she was going to pay that restitution, I didn't see that jail would be a likely outcome.
Is this something that you discussed with the victims in this case?
We have, we talked to them about the misdemeanors. We didn't really talk to them about the jail time because that's really up to the court. It's not part of the plea agreement, but we did talk to them about the restitution being the primary goal, and they agreed that restitution should be the focus of the probation.
Mr. Slepp, have you scored out guidelines for this at account for?
Not officially, but I think it's probably 0 to 6, somewhere in that range.
And we did 0 to 6, up to 0 to 11. She has no PRV. She has no criminal history at all. So it's going to be low level OVs and no PRVs.
All right, Mr. Slepp, is that your understanding of the agreement?
It is, Your Honor, but I did talk to the prosecutor just before court. My client would like to plead no contest due to civil liability. She's concerned that possibly after the case, she could still get sued.
So,
I wouldn't object to that. The court would have to review the police report, which I don't have ready. We just had that discussion, but we could, I think defense counsel may have a copy.
I have a copy of it here for your review. May I approach?
yes. Stuff I typically mark it in the police report as an exhibit to the file. So I can either take that one or I can just use it for now and before you leave today, if you can make a copy.
I would be happy to do that, Your Honor. I just don't have a copy machine. If I could use the court's copy machine.
Or Ms. Koch, if you can get a copy.
The victim advocate can go ahead and make that copy right now. She's right here.
Well, I need to use it
Okay.
for the hearing, but if we could do this after. the hearing.
Okay. Absolutely.
Thank you, Your Honor. Document, thank you.
Factual basis. All right, so Ms. Caswell, have you had an adequate opportunity to speak with your attorney about this agreement?
Yes.
And what we said here on the record today, is that consistent with what you talked to your attorney about?
Yes.
Did you want to proceed with that today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And maybe obvious based on what Ms. Koch has had to say, but you're not on any kind of probation or role at this time.
Correct.
You understand that by pleading guilty to the felony charge, that the maximum possible penalty you could face would be up to 5 years and or a $10,000 fine and 3 times the value of the property that was taken. You understand that?
I do.
And you understand that we talked about some things that may or may not happen based on how things go in probation.
Yes.
And that if you successfully complete probation, you would be entitled to a reduction in charge. You understand that?
Yes.
However, if you don't, then you could face additional penalties for violating your probation. And you wouldn't get the benefit of that reduction. You understand that?
I do.
Also, with regard to the sentencing in this case, as Ms. Cope has indicated, there isn't any agreement about what sentencing may be on this charge. So Ms. Cope indicates that she's not going to be asking for jail time. You understand that I'm not bound by that. If I think that jail time is appropriate, then I may or may not impose jail time in addition to the probation. You understand that?
I do.
With all of those things in mind, what is your plea to that charge today?
No contest.
I should have done this. Cope, do you have any objection to the no contest plea?
I don't, and we did make that copy. So
Okay.
give that to the court.
Thank you. And the court finds that civil liability is an adequate basis to accept a no contest plea, given the nature of the charges in this case. So Ms. Caswell, I'm going to go through your rights with you. You do have the right to have the trial. You do have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify to trial yourself if you want it. You understand all of those rights.
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty.
I do understand.
I'm sorry, no contest. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of that appeal. You understand that? Has anyone threatened you with anything to get you to plead no contest?
No.
Has anyone promised you anything other than what we said here in court?
No.
Is it your own free choice to enter this plea?
Yes.
All right. Ms. Cope, I'm going to mark and admit this is Crawford County Sheriff's Department report number 25120000440. I'm going to mark and admit that as Court Exhibit 1. Have you reviewed that?
I have.
And would you agree that the information contained within that report would provide a factual basis to support a finding of guilt as to this added count 4?
Yes.
Mr. Slepp, have you reviewed that report?
I have, Your Honor.
Would you agree that it provides a factual basis?
I agree.
All right. The court will mark and admit that as Court Exhibit 1. Ms. Coke, are the people aware of any threats, promises, or inducements other than what's been placed on?
No, Your Honor.
Mr. Slepp?
No, Your Honor.
And Ms. Coke, are you satisfied that the court has complied with statute and court rule in taking this no contest plea?
The court has.
Mr. Slepp?
You have, Your Honor.
Thank you. Ms. Caswell, the court finds that your plea is knowing and voluntary. The court is satisfied based on the information contained within Exhibit 1 that there is a sufficient factual basis to support a finding that you are guilty of this added count 4. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing.
Judge, I would ask just briefly, before the sentence hearing is set, I know my client would like as much time as possible to get as much money together for the sentencing. So if the sentencing could be an extra 30 days or 40 days, we would certainly appreciate that. Ms. Coke.
I think given the goals of this case, that's appropriate.
Okay, so we'll set sentencing out in 60 days.
Thank you, Your Honor.
Yes. So Ms. Caswell, it's important that you stay in contact with your attorney between now and then.
Okay.
So that you can prepare to go forward on that date. Before you leave today, you're going to meet with Mr. McFalda from the probation department to set up a pre-sentence interview. Spoke anything further on this file today?
No, thank you, Your Honor.
Mr. Slot?
No, thank you, Your Honor.
Thank you. That's all for today.
Thank you.
Okay, is Ms. Sanford present?
That's me.
Okay, Ms. Sanford, if you come forward, please. On the record in People versus Marcella Sanford is file number 265543. This is set for a status conference today. Well, as looks like Ms. Sanford, there was a failure to appear back May 18th. Mr.
Thank you.
Trush, go ahead.
Thank you, Your Honor. Richard Trush, appearing on behalf of Ms. Sanford. In regards to the non-appearance, Your Honor, she's appeared here today. At the last hearing, she had an issue with her ride canceling, and frankly, I think she just had technical difficulties in terms of getting logged into Zoom. I indicated we were in good contact with her throughout the day. I think she took appropriate actions in terms of what was going on. So I would ask the court to dismiss the show cause based on what occurred there and her appearance here today.
All right, I agree, Mr. Trush. The court will not proceed further with any sanctions for the failure to appear, Ms. Sanford. And Mr. Trush, how do we want to proceed today?
Thank you, Your Honor. We're in receipt of an offer from the prosecutor's office. It's a fairly advantageous offer to Ms. Sanford. I suspect that we're likely going to take advantage of it. I would say Ms. Sanford has sort of expressed to me that she doesn't want to have a trial, but that's not exactly the same thing as expressing that she does want the offer. We've had some discussions about it, but I would indicate she has asked if the court could give her some time. She's indicated she'd like to talk with her family before she makes a final decision, which seems like an appropriate way to proceed to me. Generally, I would say for myself, I mean, I discuss most major decisions with my family before making them. The rub of it is her son, I think, is in the Navy and currently deployed. So I have discussed with her. I suspect that the court will give her some time to try to effectuate that, but probably not an unlimited amount of time. And given where he's at, if we had 30 days, there's no guarantee, I think, that she's going to be able to do that in that time period. But we'd ask the court to consider giving a 30-day adjournment so that she can, again, at least attempt to have those discussions with her family.
I wouldn't object to a 30-day adjournment. The offer is for 2 misdemeanors, which is, as Mr. Trush indicated, very advantageous. I don't believe she has any criminal history at all. Based on my review of her criminal history, this involves a relatively high BAC and a significant amount of contentious behavior with the officers. So I wouldn't object to that adjournment, but at the next hearing, I will be withdrawing the plea offer.
Okay. All right. The case was found over in April, so, I don't have an issue, Ms. Sanford, with giving you an additional 30 days.
Thank you.
However, at some point, it's not going to be up to me anymore. Ms. Coke's just not going to offer that
Correct.
anymore. So
It's
that's
appreciated.
out of my control. So I will make that next hearing the plea cutoff. So at that next hearing, Ms. Sanford, I'll be asking you whether you want to enter into a plea agreement. If you do, we'll take your plea that day. If you don't, then I'll set up your trial and I won't take any pleas and lesser charges after that. So it's important that you stay in touch with Mr. Trush and that you come prepared with the final decision on that day as the offers. Okay.
Thank you. Greatly appreciate it.
Your Honor, may I suggest to the court the mid-month day in July as opposed to the first week, just because during motion week, I often wind up appearing via Zoom, and I think that this is a case where in-person appearance would probably be beneficial.
Mr. Trush, did you say July or June?
July. Because I don't think there is a mid-month day in June, correct?
No, there isn't. That's
Correct.
what
Okay.
So I'm not sure that I'm going to have availability for that one, Mr. Trush. So we're going to set it for early July.
Understood. Thank you.
July 9th. Okay. So again, Ms. Sanford, just make sure you stay in touch with Mr. Church.
Yeah, thank you.
I am gonna call Ms. Owens' case. This is file number 45289. Ms. Owens, I believe, without counsel, filed a motion to be discharged from her probation. Her probation was extended based on failure to pay fines and costs. This was set for hearing at 10 a.m. It's now 10:20. Ms. Owens is not appeared before the court. Mr. McFell, do you have any contacts with her regarding this?
No, Judge, she filed that motion, this court date was set. And then during that period, she also stopped reporting to probation agent in her supervised county. So she missed her reports on a couple of dates. I filed, should be at the show cause filed. There should be a show cause also.
Yeah, it's also set for a PV arraignment on the violation of probation today too. So she's got motion and then the PV show cause too.
Okay. Okay. I didn't realize that we had a show cause.
Yeah, MIDC duty counsel wasn't aware of the show cause either. We probably just overlooked it because we had gotten notice about the motion.
All right, so. So the court just will note for the record that Ms. Owens is not present. The court will dismiss her motion based on her failure to appear today to argue that motion. And then Mr. McFall, I would just request that you prepare an additional probation violation check warrant to appear.
Okay.
And then once Ms. Owens is arrested in front of the court, we'll proceed further.
Thank you.
Thank you. Okay, Mr. Michelle's, if you want to come forward, please go on the record in People versus Scott. This is file number 255502 and 5549.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Michelle's, and I did just see Ms. McGregor appear in the Zoom court.
Yes.
Your Honor, I'm taking a felony plea right now. Can we wait 2 seconds?
Yes, absolutely. Oh, we have a minute. Let's just take a short recess.
Since she needs one more moment, the defendant is still talking.
Forward at your sentencing, which we just scheduled.
Judge just scheduled sentencing.
Date and time for you to do that. So please collect your thoughts and then I'll hear any of your statements on that date as well, okay?
I just wanted to make that item prepared to you on what I understand in day and age.
I understand, Mr. Smith, and I thank you. You're all set for your hearing today and we'll see you back for your sentencing, okay?
Thank you very much.
Have a good day.
You too.
Your Honor, can we take a break so I could do my special prosecutor case?
Sure, we can take a recess. Do you know how long that's going to be?
It's just two sentencing, it's a probation violation sentencing. They're felonies, Your Honor.
All right. And we'll stand in recess.
Thank you.
You back, so just first I'll be ready.
Okay, thank you, Your Honor. Christine McGregor on behalf of the people.
Thank you. This is the date and time set for sentencing in this matter. Sir, you had an opportunity to review the two reports in this case.
Yes, sir.
And Mr. Trush, are there any additions, deletions, or corrections on either of those?
No, Your Honor.
Are there any challenges to the scoring on the new felon file?
No, Your Honor. I think there's potentially a challenge to OV2, but frankly, it doesn't change the guidelines. So we're not pursuing that.
All right. Ms. McGregor, do the people have any additions, deletions, or corrections to either report?
No, and no challenges to the scoring, Your Honor.
Thank you. Anything on behalf of the people for allocution today?
Yes, Your Honor. I think when you look at this case with Mr. Michelle's, I've been involved with him since 2025 on several cases, starting with the original case that's now on a probation violation. And then also with several cases during the pendency of that case. And if you look at that case, that was a sentencing on January 8th of 2026. There was 7411 given on that matter. And during that probationary period, Mr. Michelle's did nothing. He was still violating law. If you look at the criminal history, he had a case in March 18th of driving while license suspended. And then again on March 31st, 2026 was arrested with controlled substance possession of methamphetamine, the case that originally brought him in front of your court. When you look at, and I understand what the recommendation is, and I understand what Crawford County normally does with cases and sentencing. And I understand what MDOC has recommended. But you look at this, and this is a straddle cell. The guidelines are 5 to 23 months. I would not be doing justice. I know I don't reside in Crawford County, but for the Crawford County people, if I didn't argue for a prison sentence, and I would argue for 18 months. And these are the reasons why. Probation is given and community sanction is given for oversight of people that will use those services and for rehabilitation purposes. The defendant was given that opportunity with the possession of methamphetamine under 7411. He chose not to use any of the services when you look at a community sanction. He continued to violate probation, right? He got another driving while license suspended. While he was on bond during all of the cases, he continued to drive without his license. He dropped dirty for meth during the pendency while on bond. So those sanctions and that money and resources for your community are used for people that actually want to be rehabilitated. When you look at the defendant, I say that he isn't an individual that wants to be rehabilitated based on his continued use of methamphetamine. This new case is based on he wasn't reporting to MDOC, he absconded. They went out to his house, they find him at his house, he has possession of methamphetamine, he's enough to maintain a drug house, he has firearms. All of those things show that he's not a community sanction. And are we going to waste county resources on an individual that doesn't want help? And I think that's the argument that needs to be made. You can look at his criminal history and say, well, he doesn't score out on PRVs because of the 10-year gap and all of those things by virtue of statute, and that's accurate. But look at his ability to comply with orders, bond orders, comply with probation orders. He will not comply with that. So we'll be back in court within the next 6 to 8 months on another probation violation because he refuses to take accountability and do what needs to be done. When you look at those cases, and I argued in Judge Burmeister's court under a misdemeanor sanction. I don't live in your county. And in my county, I argue for prison on this for several reasons. The first case that was involved him driving, I believe, and he had a bond violation, driving under the influence of methamphetamine. So you're having this individual on your roads. It's a safety issue for your community. He doesn't take it seriously. And at some point when he kills someone driving without a license or on methamphetamine, we're all going to look back and say, well, that just happened. No, there's avenues that can be taken. He chooses not to be rehabilitated. He chooses not to use the community sanction appropriately. And at some point, that in terms orders a prison sentence. And I was very blunt during sentencing with Judge Burmeister. I said to the defendant, I'll be ordering prison recommendation for you because at this point I don't believe you're community sanctioned, and at some point I'll be a special prosecutor if he doesn't go today to prison and just gets the 8 or whatever months that are recommended. I'll be a prosecutor again on another one of his cases within the next 6 to 8 months that I'll be arguing for prison again because he will not quit his behavior. He will not use the resources that the court has given him and MDOC has given him and misdemeanor probation has given him and your county has given him. So he's going to continue to violate the law. He's going to continue to use methamphetamine. He had children in the house when he had the methamphetamine in that home. It's a safety issue to his child. So based on the totality of circumstances, I believe a prison sentence is appropriate in this manner, and I would request 18 months, Your Honor.
Thank you. Mr. Trush?
Thank you, Your Honor. Frankly, I couldn't disagree with the prosecutor more on this case. I mean, to start with, she frames the original underlying offense that we're here for the probation violation on as he was driving under the influence of methamphetamine. That's not what bears out in that report at all. What bears out in that report was he was pulled over, driving on a suspended license. There was methamphetamine in the vehicle. There's no indications in the report in any way, shape, or form that he was using the methamphetamine while operating the vehicle there. And that is an important distinction. In regards to this case, again, she frames this as he is absconding from probation. Again, I don't think that's accurate. He was in contact with Mike McFalda. Mike McFalda asked him to come in to report, and it is in fact true that he did not come in and report, and he indicated to Mike exactly what was going on. There was a warrant for him for a DWLS. He knew that. He didn't want to get arrested yet. Mr. McFalda gave him a week to take care of that warrant. That's the background that comes here. The prosecutor frames this as there's methamphetamine in the house and this is a danger to his child. I take a great deal of issue with that. The methamphetamine was found locked in a safe. I'm not going to advocate here and say that having methamphetamine in the house is a good idea, but certainly having it locked in a safe, if you're going to be using that, is among the safest ways to do it. And quite frankly, in some cases, is the safety plan that DHS will put in place if somebody is a user and has that in their home with children in the home. I've seen that as a safety plan in numerous cases. So I take a great deal of umbrage there. Your Honor, sentencing should be progressive. Sanctions should go up as there's continued behavior. And I'm certainly not going to argue to the court that that's not what should happen here. The sanctions should go up, but I think the court should look at a couple things when thinking about that. One, what was the sentencing in the underlying offense? In the underlying offense on this, he didn't serve really any jail. He served 2 days with 2 days credit and was placed on probation. So any jail sentence here is a significant increase from what was done in the last case, a progressive sanction. We don't want to jump right to the highest end sanction of MDOC because, again, what we're going to do then is over punish people who can be corrected with lesser sanctions. In addition to that, there's another huge penalty here that's being sought and will certainly be imposed by the court that's being underestimated. And that's that he's going to lose the benefit of that 7411. And that in and of itself is a significant penalty that he's going to face in this case. And that now he's going to have that on his criminal history, as well as the new charges on his criminal history, which significantly raise his prior record variable scoring if he does continue this behavior in the future. Your Honor, Mr. Michelle's is a person who is a good member of our community. He is a person who, frankly, for my discussions with him, I think wants to get back to his normal life. He's had a lot of strife in the last year. He's gone through a divorce. He's gone through these cases. I think a jail sentence here is appropriate. Frankly, 8 months seems like a stiff jail sentence to me, given what the last sentencing was, given the penalty he gets by losing the 7411, and given his specific prior record. I think the jail that he's already served up to this date has had a profound impact on him. But I think an 8 month sentence is a steep penalty here and steeper than is necessary. I would suggest to the court the lower end of the guidelines is probably what's appropriate here, knowing all the other things that come along with that. Thank you.
Thank you. Mr. Michelle, is there anything you wanted to say?
I'm terribly sorry for wasting everybody's time. I can do good. I am a good person. I do love my family. I love my freedom. I do a lot of work in the community. I'm a contractor. You know, I go into people's houses in and out. I am trustworthy. I did just go through a divorce. Did kind of knock me down quite a bit. I need a driver's license. That's a big thing. I have a lawyer hired for that. If I could get the chance to do good, I think.
All right, well, I read through the reports in this case. I was already familiar with you generally and your circumstances based on the original case that we had. And then, of course, I read through the new report of the additional criminal conduct that brings you before the court here today. I've listened carefully to what both the lawyers have had to say. They both, I think, done a good job of articulating their respective positions and views of this. And I take what you've had to say into consideration as well. And looking at all of those things together as a whole, number one, you know, I recognize that everybody that comes before me isn't just one thing. Everybody has the potential to do good things, and I'm sure it's no different with you. And you've gotten yourself into a situation here that's created a great deal of trouble for you and has made it more difficult to do the good things that you want to do and be involved in the things that you want to do. I have no doubt that, you know, at some point you can get back to that. But there is there's a consequence to be paid for your behavior over the past period of time. And, you know, the probationary period did not go well at all, as you know. Everything Ms. McGregor stated in terms of your violation behavior is absolutely correct. There were no payments at all made towards your fines and costs, and you continue to engage in violative behavior. It is concerning to me, and I certainly appreciate Mr. Trush's argument that if you're going to have methamphetamine in the house with children, the safest, the best place to put it. Whereas the best thing is to not have methamphetamine in the house with children at all. And so I don't find that the storage thing is really a mitigating circumstance, and I think that presented a legitimate danger to children. And
May I say something?
Sure.
I never had a chance to make a payment. I mean, I could pay my fines and costs off and pull it tomorrow. I never even got that chance yet. So the money thing's not, you know, the issue, the fines and costs. I did have a prior warrant for that arrest. had every intention of coming the next day to come see Mr. Mike. I thought we were in agreement with that, but apparently it was a misunderstanding. I got arrested on a Sunday. I was coming to see him on Monday, but I was all signed up for the Grace Center for my counseling, which was prior to that week before I came into jail. So I mean, I had everything on a roll of going.
Well, I mean, I don't know. You had plenty of time to drive with a suspended license and have more methamphetamine. So,
okay.
I mean, right? So we saw what happened and what didn't happen. And what happened was you got your hands on more methamphetamine and you didn't do any of the other stuff. So not sure the timing is really the most important part of that whole situation. It's what you chose to make a priority. So looking at things as a whole, I do think a greater sanction is appropriate. I do know in the PSI that you would be eligible for the boot camp program. I think that's a good option for you, given that probation did not go well. And I think that's going to provide a different experience for you that may have more of an impact than anything that we've done so far will. So as to the new charge, the court is not going to place you on probation again. I don't see any value in doing that to the community, placing you on probation again when the first term had absolutely no effect. The guidelines, as indicated, are 5 to 23. The court is going to sentence you to 18 months to 10 years on the methamphetamine charge. In the Michigan Department of Corrections, you do have credit for 65 days served. I will not have an objection to your placement in the boot camp program, which would allow you to be released significantly sooner than that. And there's, again, all indications that you are eligible for that. As to the maintaining a drug house charge, the court is going to sentence you to 12 months in the Crawford County Jail with credit for 65 days served. That to be served concurrent with the sentence for possession of methamphetamine. In terms of the probation violation, the court is going to sentence you to 6 months in the Crawford County Jail. You do have credit for 67 days served. That time to be served concurrent with your sentences in file number 5549. The court is going to order that your probation be discharged unsuccessfully and your 7411 status be revoked. The court will preserve any outstanding fines and costs. As to file 5549, the court will order a $130 practice assessment, court costs of $325, attorney fees of $350, $136 state costs. You do have the ability to seek an appeal of this sentence. Mr. Thompson, can you assist Mr. Michelle since yes, Mr. Church is not here?
Yeah, you just got it.
Your Honor, I just have one question for the court.
Yes.
Based on the sentence that the court issued, what does the court anticipate will happen should Mr. Michelle's complete the boot camp prior to the 1 year county jail sentence expiring?
That's a good point. The court would hold in abeyance any time after that might remain. If he's eligible for the boot camp program and isn't released between that time, I wouldn't want him to go back to jail after that. So thank you for mentioning that. That's a good point.
Thank you, Your Honor.
You reflect that in a sense.
Okay, Judge, I'm sorry, can you say that one more time?
So if Mr. Michelle's participates in the boot camp program and completes it prior to 12-month sentence, the court would hold any remaining jail time in abeyance.
And that's on the 5502 case?
No, that's on 5549.
Okay.
Maintaining drug discharge. Thank you. Mr. Churstad, that'll be in the judgment of sentence.
Thank you, Your Honor.
Your Honor, if there's a procedure for me to indicate that the defendant has been provided with these, he's indicating he doesn't want to sign anything at this time, and his attorney's not right here to sort of speak to him, so I don't want
Mr. Trush, did you hear that?
to pose that on him.
Yes, Your Honor. I will get, if Mr. Thompson could take the paperwork with him, I'll go up to the jail and speak to him either this afternoon or tomorrow.
All right, thank you. Okay, you are remanded to the custody of the state at this time, Mr. Michels.
Thank you, Your Honor. Have a good day.
All right, thank you. You're free to disconnect, Mr. McGregor.
Thank you.
Versus David Law. Mr. Law, you come forward, please. District Court.
Oh, okay, I'm like, I do not have him on my docket.
And Your Honor, MIDC didn't have him on our, so I'm just.
This is
asking
something,
if I should be involved or not.
yeah, I mean, if you don't mind staying present here in the courtroom. This was set by District Court. It's a case that I have for Judge Burmeister get disqualified, and it involves a show cause for payment of fines and costs. So let me get the file here, but I believe Mr. Law, I don't know, is that a printout of what you paid and unpaid?
This is the motion.
Oh,
Mr. Law brought his copy of the motion, so now I know the allegations. I haven't had a chance to get Mr. Law.
So, Mr. Law, you're before the court today for show cause for failure to pay on your fines and costs in this case. So you were originally assessed $1,065 for fines and costs. It looks like you paid $50 towards that, so the remaining balance is $1,015. So at this hearing, the purpose of this hearing is to determine why you haven't been paying, if you have the ability to pay some or all of that, and whether or not you know, what you want to pay. And so
I do have the ability to pay or get on payment plan. I was under the assumption I was confused, and I'm sorry about that. When Mrs. Norton wrote me word, Mr. McFelda, that my fines and costs, I didn't understand that. They would just go to Mr. McFelda. And I've been compliant with everything that he said. And I've done the class and it's been really good for me. I just got a new job Monday.
Okay.
I lay flooring. Okay. So things are going good. My life's going good. And yesterday, before I went to see Mr. McFelda, I went and paid a little bit that I just had in my pocket. But yeah, I could get on a payment plan, or I could just come in here when I see Mr. McFelda and pay a couple $100. That would work.
Do you report monthly?
Yeah, I report directly.
And so how much would you be proposing to pay every month?
well, this I want to make sure that we're clear because he's got exempt felony probation. This is a different thing.
Okay.
So what you're paying to Mr. McFelda doesn't go towards this one.
No, I'm not paying to Mr. McFelda. Mr. McFelda told me to kind of get my life back in order because I was in jail for 7 months and save some money. And then we would go over it because I had him for 5 years.
Right.
So I just been paying through the district.
Okay. And that's been going for something else because this doesn't show.
And I just realized when I got this paperwork, because this goes to my father's house, and I kind of say at 2 different locations.
My concern is I don't want you to over commit to this one with your, because it sounds like you're paying on a couple different files.
I'm just paying for this one now.
That's why I think there's confusion because this doesn't show. If you've been paying money, it hasn't been going towards this one.
How many cases do you still have to pay on? Is the judge's, one of the judge's questions?
Just this one and the one for Mr. McFelda.
Right, okay.
So you think you have 2 cases with some kind of balance?
Yeah, that's what, I think I owe like 1,000, close to the same amount.
Yeah, that makes sense.
Through Mr. McFelda, and he just said, just get some money saved up and so.
Okay, so what I'd like to do is get you on a plan for this file. And what I'm gonna ask you is, I don't want you to overestimate, because I don't want to set you up for failure. So what do you think realistically on a monthly basis you could pay towards this?
I could pay $200.
Okay, that sounds like a lot.
Okay.
And are you intending to say 200 on each or 200 total?
Just 200 for this. For this
Here's
one,
Mr.
not.
McDowell. Hey, Mike, can you help us out a little
Sure.
bit here? So we got Mr. Law here. We're here today on the district court
Yeah.
file. And this was set for a show cause for not paying fines and bucks.
Okay.
And he was assessed 1,065, he paid 50, so he owes 1,015. My concern is, we're trying to establish he's on probation with you.
Right. On the felony file.
Right, so I'm trying to get a reasonable payment on this file and not have him overcommit and then not be able to pay on one of them.
Right. I know he's back working. He seems like he's working steady. I don't know.
Do you know what you have him paying?
I don't really set monthly amounts. Wait, have you paid anything on the felony?
I
file?
haven't on yours yet.
Sometimes with the district court, I kind of let them get those squared away because their guideline, they're really, I don't want to say strict, but they're really tight on their guidelines there. So I kind of let a lot of these guys pay that off, knowing, and I tell them you can't get off our case until you're paid full. So with him, I think he's going to be working. I don't foresee there to be a problem. Just I tell them don't overpromise to the judge. Right?
Okay.
Yeah.
So we're just saying.
I could definitely get away with $100 a month. And if I could pay more, I will pay more.
Why don't we do that?
Okay.
All right, so I'm gonna know for the file that you're gonna pay $100 per month on, and make sure this is the district court file. Yeah, when you do payment plans, do we put any kind of order in place, or is it just something that's noted for the record?
We have like a finance portal, so we put it in there, so he gets like monthly letters and like reminders if he doesn't pay, so we'll put them in that payment plan.
Okay, for $100 a month.
Yep.
Okay, great. All right. So, if you have any questions, talk to the district court. They'll help you, but it sounds like they'll give you that information about your payments. Okay.
Thank you.
Do you have any questions about that?
I do not.
Do you need anything more from me on
Nope,
this?
we're all set, thank you.
Great, thank you.
Sorry for wasting your time.
No, not at all. You got it solved. That's good.
Yep, there's you do.
Mr. Flagstead, were you ready on Mr. Jackson?
I sure am, Your Honor.
It's file number 265535. The record should reflect that Mr. Jackson is present here in the courtroom today. This is the date and time set for discussing this matter.
Judge Mike Flagstead, P number 79314 on behalf of Mr. Lajak.
Garrett Coke on behalf of the people.
Thank you. Mr. Lajak, have you had an opportunity to go through the pre-sentence report and talk to Mr. Flagstead about that? Yes. Mr. Flagstead, are there any additions, deletions, or corrections for that report?
No additions, deletions, or corrections, Judge. I do have maybe just one item to address my allocution.
Any challenges to this one?
No, Your Honor.
Ms. Coke, any additions, deletions, or corrections?
No, Your Honor.
Challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, the defendant presents on this fourth drunk driving, but it has been over 20 years since his last one. His blood alcohol was relatively low, just over the legal limit. I think the sobriety court program is a good program for him. I know Mr. Claxton has done a lot of work to make sure this went properly, because every one of these courts is completely different. And so he's done all the paperwork that's required. And I think it's an appropriate sentence in this case. So I'd ask the court to follow it. Thank you.
Judge, I should have asked already if I could approach. I do have some character letters as well as a letter of acceptance from the Lenawee Sobriety Court.
you want these attached to the PSI or did you want it back?
You could attach them, Your Honor, that would be fine.
Anything for allocation?
Yes, Your Honor, may it please the court. I do appreciate Ms. Coates' comments. I largely agree. In discussing this matter with my client, I've discussed with him and he admits there's no talking our way around a forced DUI. It is what it is. That being said, Judge, his most recent offense was in 2004. He's been 22 years without a speeding ticket, which I think also says something. And in discussing it with him, what I've listened is that this was an issue he thought he had buttoned up. He thought it was addressed. He thought it was solved, so to speak. And I think in retrospect, reflecting on it, he's recognized, okay, I need a little more diligence here. I let this slip through the cracks and I need to look at it. What is a little bit exceptional about his case, Judge, as you are very well aware, many people end up in sobriety court because they don't have a license, either because they're losing their license or they didn't have one before, and this is really the only reasonable path to get one. That's not the case for Mr. Lajak. He's actually not going to be losing his license because he had a full license. So as far as the Secretary of State is concerned, they view this as a technical first offense. Mr. Lajak is voluntarily agreeing to have an ignition interlock put in his vehicle. He wants to address this problem. He doesn't want to be looking at this problem into his 60s and 70s. He wants it wrapped up once and for all. Judge, I think the character letters also reflect that same kind of attitude, that this is a conscientious, hardworking, productive member of society who does not want to be in your courtroom handling problems like this. I think he's going to do well in sobriety court. I'm optimistic for his future, and I hope this is, the punctuation at the end of the sentence. That's all I have, Your Honor. Thank you.
All right, thank you, Mr. Lajak. Anything you wanted to say today?
Yes, Your Honor. It's been 6 months since the offense, and a lot of thoughts have run through my head in that time, and clarity has inched into myself on what I did. And the basic bottom line is I made a mistake, and it won't happen again. It's something it's very embarrassing at 58 years old. Trying to do all the right thing all the time. I cannot explain why I did that. And I apologize to you, the city of Grayling, and especially to the officers, Grayling Police Department and state troopers as well.
All right, well, I read through the report, so I'm familiar with the charges that bring me before the court here today, along with your past history. There's a lot of information in the report about you and your circumstances. And so I take all of those things into account, along with what the lawyers had to say and what you had to say. I do think this is an appropriate resolution. I think the sobriety court program is a good program. It's not easy. It's very demanding. But for people who genuinely want to get through it and benefit from it, but once you graduate, find that it's extremely helpful in providing them tools to prevent further relapses. And I think, your case is an example of who are able to maintain long periods of sobriety and then have relapses. And I think it really shows how it's a lifelong thing. It's not something that said that you can never really have fucked up. You have to remain vigilant. And one of the things that the sobriety court will give you is those kind of tools to help you as you go forward. So I think it's a good program. I think both the community and the court and yourself will all benefit from you participating, because I think it will prevent further risks to the public safety posed by so the court is going to follow probation. The court is going to sentence you to probation for a period of 2 years. The court will adopt all the terms and conditions of that probation, the most important of which, of course, is that you not use or possess any alcoholic beverages or any controlled substances unless they're prescribed to you, that you complete any outpatient or residential substance abuse treatment that you are referred to, and that you participate in and successfully complete the Illinois County Sobriety Court program. Court is going to impose 12 months in the Crawford County Jail with credit for 2 days served. The court will hold that time in advance. If you successfully complete that program, then you will never have to serve that time. However, if you don't, there's a significant consequence. The court is going to order court costs an amount of $325, a fine of $500, a OUI reimbursement of $100, $68 state cost, $60. I know, Mr. Gonzalez, I think we talk about this every time. Do I need to? This is going to this right?
Yeah, I think he still will be supervised by Department of Corrections. I know every county is a little different, every situation is a little different, but most times I'm gonna transfer him down to that county, and then he will be kind of dual supervised.
Okay, so we'll do 35 months supervision during probation. You do have the ability to seek an appeal of this sentence, and Mr. Peck said the appellate rate should be on the table next to you. If you want to have
Oh, I'm sorry.
you can, that's 12 months held in abeyance. It's going to be 6 months held in abeyance.
I appreciate that, Judge.
For
6 months jail.
6 months. Yeah.
Oh.
That's under the annex. Held in abeyance for 2 days. Okay, did Mr. Jack get his appellate rights?
Yes, Your Honor. I also have a copy of the MOU. I may appropriate that as well.
Yes.
And Judge, might I be heard briefly on the probation supervision fee? I guess only insofar as the MOU contemplates payment to the Lenawee County Circuit Court. I guess I do view that as duplicative. And my understanding is that, okay, Ms. Medler's telling me I'm not correct about that.
Are you talking the 750?
I am.
Yeah, the 750 is the program fee. It has nothing to do with probation oversight fees.
Okay. Apparently I lost that argument.
I'm gonna hand this back to you.
Thank you.
Anything further?
No, Your Honor, thank you.
All right, Mr. Lejack, good luck to you.
Judge, might I actually leave this with the clerk perhaps for the supervising judge's signature, or do I need to talk to his assistant?
Oh, Judge Hunter has to sign.
Okay, I can take that. Have him.
I can trust you with it?
I hope so.
Thank you, Your Honor.
Okay, thank you. That's all for today. What's that? Yeah. we got-
Anthony? Anthony? Oh, there you go. Okay.
Okay, we'll call Mr. Doring's case. This is file number 255475. The record should reflect Mr. Doring's presence here in Portland today. Thank you, counsel.
Sierra Coke, on behalf of the people.
Thank you, Your Honor. Jason Thompson, defendant Anthony Doring.
Thank you. Mr. Doring, please. Thank you. All right, we're on the record here today. Ms. Coke, you filed notice to have certain evidence reading or to admit certain evidence regarding the past acts of the defendant. Can you just make a record of the evidence that you're trying to seek admission?
And we attached the information from the last report, and I did correct the citation on the record last time to 768.27B, which I spoke to defense counsel about. This is just, and I realize that it has to be, the court has to make a decision that it's, that it meets the standard because it's over the time period. This is just a history of Mr. Doring's behavior and how he acts when he's in a situation that involves his partner making decisions he doesn't like. This is his pattern. It's what he did then, it's what he did now. I understand defense counsel and I don't agree on that, and that is why I filed this. And then depending on, this case is first in line for trial, depending on what happens today and whether or not that trial goes, Jackson is second. So, thank you.
Mr. Thompson.
All right, thank you, Your Honor. First of all, I don't think there's any factual dispute that this is over the 10 years that's contemplated for admission. I haven't heard any good cause for the court to consider any other basis of admission. Obviously, we believe this would only be used by a jury for propensity. Propensity evidence is generally discouraged. The legislature did carve out an exception for this 10-year period, and we're outside of it. And, you know, Professor McCormick said propensity evidence proves too little and too much at the same time. It doesn't have any logical relevance, but it has a lot of effect on a jury. And so it's historically been excluded. We are respectfully requesting that it be excluded in this case, Your Honor. And I don't know that the prosecutors really brought it up. I mean, Mr. Doring is considering testifying. So I would understand if she was also seeking to use it as cross-examination as to his prior acts or character, but I believe it's similarly excluded under that regard. So to the extent the court would opine on that, you know, would be helpful for the defense to understand it. Obviously, if you opened the door and said, I would never, you know, touch a woman or something like that, then obviously that would make it relevant. I think as it stands, it's not relevant. Mr. Doring is 58 years old. Respectfully, having one conviction over 10 years ago is not a pattern. It's the opposite of a pattern, Your Honor. If something happens once. So respectfully, we're asking the court to exclude this under 76A 27B. And thank you.
Anything you wanted to state in response to this bill?
And Your Honor, I would say we are over the 10 years. We're not very far over the 10 years based on the offense dates, but it is over. So the court would have to review the facts that we had put in our brief. Thank you.
All right, I'm just gonna take one brief break here and right back to the court's ruling. Thank you.
Thank you, Your Honor.
All right, please.
Okay, we're back on the record and people are snoring. I wanted to take a break just to address that issue of cross-exam, because that's not something that I had considered before as part of my initial review of motion and response. So looking at the issue of whether or not the prosecutor can introduce evidence, and I think it would apply both the prosecutor's case in chief and any cross-exam. Whether the prosecutor can introduce evidence of the prior incident, it is clearly beyond the 10-year period allowed by statute. So that brings us to the interest of justice exception. That exception, based on case law, has to be narrowly construed by the court. Evidence has to be uniquely probative, and or the court must find that the jury would be misled without that evidence coming in. In this case, the court finds that the evidence regarding the prior assault does not meet that standard when looked at, when the court narrowly construes that. There are certainly some similarities in the two instances, but I don't find that they're so similar that the earlier incident would be uniquely probative. And certainly that the jury would be misled without that evidence. There is a significant passage of time in between the two incidents. There's no evidence of any similar acts by the defendant during the interval. They both involved violent acts, but I don't find that the acts themselves were so similar, or the circumstances surrounding those incidents were so similar that it meets that uniquely probative standard. So in the discretion of the court is going to grant the objection by the defense to the admission of that earlier incident. However, I will say, and again, I don't think it can be introduced by the prosecutor at cross-exam. However, I think there may be any number of circumstances where if Mr. Goring does testify, that the door could be open for the prosecutor to use that incident, for example, for impeachment purposes and so forth. So again, I'm simply, the order simply would apply to the prosecutor's introduction.
Understood. I can prepare that order. Okay.
I think we may have attached it as we usually do.
I don't recall, Your Honor.
But if not, that's fine. Thank you.
Ask your exhibits with,
I don't know that you filed anything for that objection.
you usually do, Ms. Cope, but there was not.
Okay, thank you.
All right, so with that issue addressed, Mr. Thompson, trial.
We're proceeding to try, Your Honor, and I'm orally advising the court that I'll be submitting a proposed lesser included jury instruction. I think either simple assault or domestic violence within the facts. I believe Ms. Cope's going to advocate for the domestic violence as the lesser included. I think either one would fit. I don't think there's any dispute there in a domestic relationship.
Okay. All right, so that'll be something that we'll address as part of the final instructions once the proofs are in. And I believe that instructions have already been submitted in this. Is that right, Ms. Cope?
I have Ms. Cope's.
Okay.
Yeah, I have them with the date of 5/21 on them, Your Honor.
All right, Mr. Thompson, do you have objections other than the admission of a lesser included?
I don't have objections. I intend to supplement the proposed instructions with that one.
All right, if you can just make sure that those are, I'd like to have a word copy of those.
Yes, word copy, and then with the court like 12 hard copies.
No.
Okay, no, I will send a word copy.
Okay, thank you.
Thank you.
All right, anything else on this case, Ms. Cope?
I don't know if we have to put on the record, but with the court's ruling and the fact that now this is proceeding to trial, this was first in line. So I know we'll address it, but the other case will come off.
Yeah, the court will adjourn to Jackson trial. We'll have to reset that one. This one will go next Friday. So Mr. Doring, just make sure that you stay in touch with Mr. Thompson between now and then. all counsel and Mr. Doring should all be in your seats ready to go by 8:30 at the morning trial.
Yes, that's June 12th, Your Honor, and I just wanted to say that for Mr. Doring's benefit, because, there was some mail going around earlier, and I just want to say that for Mr. Doring's benefit, that we're on June 12th. We'll all be here.
Correct.
All right. Thank you,
June
Your Honor.
12th. Okay, thank you.
Thank you, Your Honor.
Yeah, Mr. Thompson, while you're here, let's just address Mr. Jackson's case for the record.
Yeah.
People versus Christopher Jackson, based on the Doring case, which had priority. This case will go forward. I will set this for a show cause hearing at the court's next date for Mr. Jackson and status conference based on his non-appearance today. So anything further on this file?
No.
Nothing further. Thank you, Your Honor. I am in probate court at 11:30. Ms. Bradley is here, so.
You want to take your case right now?
If we could, Your Honor.
Okay.
Mr. McFall is not here. Did you hear him say that's an adjournment here? Oh, there it is.
Okay, Ms. Bradley, if you can come forward, we're gonna call People versus Alexis Bradley, file number 245301. The record reflect Ms. Bradley is present.
Thank you, Your Honor. Jason Thompson on behalf of defendant Alexis Bradley. Your Honor, I believe Mr. McFall is going to request an adjournment to allow Ms. Bradley to continue with some programming, and I think that's a very good idea. Now we'll join that request.
That's correct, Judge. I spoke to Ms. Bradley also, have read the case notes from her supervising agent. She is in the process of trying to reestablish her treatment. I think I said I would ask for 60 days. I think 90 days would be more appropriate, just so I could get a better view of how she's following through. I talked to Ms. Bradley about that in the lobby. She understands if she doesn't follow through, that I'll be proceeding forward with the violation.
Okay. Ms. Bradley, do you have any questions? Okay, so just make sure that you stay in touch with your probation agent, follow through with that. Okay.
All right.
Thank you. That's all for today.
Thank you, Your Honor.
Mr. Bobo, are you able to hear me okay?
Yes, Your Honor. Good morning.
All right, good morning. We're on the record now in People versus Mark Green. The record should reflect Mr. Green's present here in the courtroom today. Mr. Boville, his counsel, is present by Zoom video, and Ms. Koch is present here in the courtroom. This is set for a status conference today. Mr. Boville, can you tell me where things stand from the defense side?
Thank you, Your Honor. I did receive a pretrial statement plea offer from the prosecutor that if the defendant entered a plea to an added count of possession less than 25 grams and acknowledged his habitual offender second status, then the other count one would be dismissed. I've reviewed that with my client. I scored the guidelines and I sent them up to Mrs. Koch to see if she thought I had it right, because I had asked the prosecutor's office, because I didn't know for sure how to score it without having the criminal history. But I did score it. I don't know if Mrs. Koch has had a chance, but we scored it out at it would be 0 to 7 with that plea months. And if that's accurate, my client said he wishes to avail himself of that offer. I don't know if she disagrees with that or not. I wouldn't want to have my client plead to something and I misrepresented the guidelines.
Let's go.
Your Honor, I don't score out the guidelines and have them binding on defendants, primarily because whether or not things like 10-year gaps come into play depends on things like when they got off probation, when they were paroled. A lot of that information I don't have. They also sometimes have criminal histories in other states I don't know of. So it gets me into a position where I'm trying to represent something I don't have any knowledge of. So he may be right in the guidelines. I don't know the fact we told them what we can see on the criminal history. Criminal histories aren't always complete either. A lot of times they find things that we didn't know existed. Usually a defendant should probably have a much better idea of what their criminal history is, especially if it involves out-of-state things and things like when they got off of probation. But I'm not in a position to ever answer that question. And one of the things he was asking is, there's a 10-year gap. He was convicted on 3/5/03 of OWI second, and he was convicted in 1998, a delivery. There was some prison time and some jail time. I don't know how long he was on probation before he got his next charge in 2014. So I would rely on defense counsel to make those determinations. And I'm not willing to hold myself to the guidelines. I don't score them. The court scores them. And if they want to take the plea, that's fine. If we want to go to trial, we can go forward towards trial.
Okay, so Mr. Bogle, it sounds like, you know, and I guess it, you know, Mr. Green too, you know, this is, I'm not going to be able to guarantee specific guidelines at the time of the plea. So I don't know where that leaves you in terms of how you want to proceed or how Mr. Green.
Right. Well, I guess Mr. Green probably would know. I mean, in 2014, there's a 12-year gap then to 2026 for no insurance misdemeanor ticket. But in 2014, from what I received from the prosecutor, he was charged with an OWI third, which I would assume you were off probation maybe within, how long did it take you to come off of probation on that case?
Mr. Bogle, I'm just going to stop you. I mean, I don't want to engage in trying to score out the guidelines on the record here. I'm just not going to do that. What I'm going to say is, if you think it's 0 to 7, you know, then you're going to have your client, you and your client are going to have to go on that. If it turns out that it's scored differently than that, then it's different. So I'm not going to be able to represent any particular guidelines at the time of the plea. So it's going to come down to whether your client wants to go forward based on what you've done so far or not.
Right. So that's, Mr. Green, that's, you heard the court. So if you were still on probation on the 2014 OWI case, then there wouldn't be a 10-year gap. So then it would be scored higher. But I don't know exactly. I didn't represent you, so I can't tell you whether there's a 10-year gap or not. So if you want to take the plea, I would recommend that you know when you came off of probation.
I want everybody to understand that even if we know that, there might be other information that might affect the scoring that none of us are talking about today. So what it comes down to, Mr. Green, is if you take a plea, the guidelines are going to be what they are, whether they're 0 to 7 or something else, based on all the information once the Department of Corrections gets it. So, but there's no going back once you take a plea based on what the guidelines are, because I'm not going to represent to you that they're anything in particular, one or the other. You know what I'm saying?
Sure. Yeah. But if I know myself, like this prosecutor mentioned, that I would know best.
Yeah.
So going by what I know, there was nothing in between any of that. I would feel comfortable going forward.
Okay.
Because I do know that. I'm glad that she did mention that, because I would be the only one that would know that, and that you know that there wasn't anything hidden in between
Okay. But I just want you to be clear that even if you're wrong about that, there won't be any going back to where we're at. And it's always going to be that way. Nobody's ever going to be able to guarantee you before you get your guidelines.
Yeah, well, I haven't been in jail or anything like that last occasion. So I do know that for sure. I don't know what other hidden things it looks for, but I haven't been to incarcerated or been in jail since that last. You know that.
So with all of that in mind, did you want to go forward with that plea today?
Yeah.
Okay.
Yeah, because I personally don't.
Okay, all right. Then I have you come around this way up to the podium. That'll just make it easier. So I don't have to actually keep turning around. Ms. Cope, what is the maximum penalty for the possession? Is that the 4-year?
It is a 4-year, but with the habitual second, that would make it a 1.5 times so it'd be 6 years.
Okay. Okay, so Mr. Green, can you raise your right hand, please? Do you solemnly swear, other hand away. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Are you currently on any kind of probation or parole?
No.
And so this added count of possession less than 25 grams, is that what it is? Or is it more?
It's, yeah,
25?
less than 25 grams.
Oh, less than 25 grams. So as a habitual second offender, that charge carries with it a maximum penalty of up to 6 years. Do you understand that?
Okay.
Is that a yes?
Yes, sir. Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during the trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights. You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we've talked about here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
The information I have indicates that this happened back on March 14th of 2026. Is that the correct date?
I believe so. Yes, sir.
On that date, were you present here in Crawford County?
Yes, sir.
While you were here in Crawford County, did you have possession of some cocaine?
Yes, sir.
Did you know that that's what that substance was?
Yes, sir.
Did you have any legal right to have any amount of it at that time?
No, sir.
Ms. Koch, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Bogle, are you satisfied with the factual basis?
Yes, Your Honor.
Ms. Koch, are you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Bogle, are you?
No, Your Honor.
Ms. Koch, are you satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Bogle, are you?
Yes, Your Honor.
Thank you. Mr. Green, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, you'll meet with somebody from the probation department who will do a pre-sentence report. You'll have an opportunity to go through that with your attorney before the sentencing hearing. Ms. Koch, is there anything else that we need to address on this file today?
No, Your Honor.
Mr. Bogle, is there anything further we need to address on this file?
Yes, Your Honor. I would ask that the court consider, I mean, I scored it out. It's if I have it correctly, it's 0 to 7 months, 0 to 6, but with the HOA, it would go to 0 to 7. And since it's probationable, I've talked to my client a few times from the jail. He has a dog and a business and clients. He's a builder, as what we went through before. I would just ask that, I mean, he's learned his lesson. I think he's been in now for 17 days. And he said he'll do whatever the court, whatever the terms are on sentence and dropping and everything else, that he'll comply and he won't miss anything. And he realizes things could get a lot worse. So I just ask that the court grant him a PR bond today and then meet with probation and come back for the sentencing.
All right, at this time, the court is not, I'm not going to modify the bond, Mr. Green. This is a situation that, I mean, once a plea is entered, you are guilty. This is no longer a matter of pretrial release. And given the previous concerns, I think it's prudent to have you remain in custody until the time of sentencing. So of course, that request. And Mr. Bobo, the only other thing that I would indicate is that for the sentencing hearing, I generally require counsel to be present here in court with their client for sentencing. So I will ask you to be here for that hearing, and the court will send out notice of the date and time of that to counsel and to Mr. Green.
Would the court staff contact, is that possible, just to see, so there's no setting it where there's so there wouldn't be a conflict?
I have particular motion days. I have a 3-county circuit, so I only have sentencings and pleas and criminal hearings in Crawford County at certain times. So it'll be, is it July 9th? It'll be set for July 9th. I can't give you a time yet, but it'll be set at some point during the day on July 9th.
Okay, yeah, I think I already have a jury. There's a jury conference. It's set then already right now for a jury conference again for something. I'm not sure why, but maybe I marked that wrong. Would that be at 11 o'clock?
Again, I can't give you the time, so
okay.
I don't know.
Well, July 9th is a good date for me, so have a good 4th of July, and we'll see you on that date.
All right, thank you. You're free to disconnect, and Mr. Green will have you go. That concludes the court's morning docket. The court will be in recess.